Well, a very good day to you, ladies and gentlemen. Welcome to another episode of the Candid Talk here on Herman Manyora's YouTube channel. Remember, this is Kenya's most comprehensive political analysis show, hosted by yours truly, Evan Sokinyi. I'm joined by Professor Herman Manyora. How are you, sir?
Oh, I'm okay. I'm good.
We are here, and of course, Okiya Mtata is back to the court. He said he's heading to the Supreme Court to petition the recent ruling by the Court of Appeal that actually lifted the suspension that was put therein by the High Court therein, and he's arguing that one, he wants the entire Finance Act removed by the government. He said it should not actually work and continue being there in effect. Now, let's begin from there. What do you make of the decision of the Court of Appeal to lift that suspension by the High Court?
You see, things when they're in courts, I really want to discuss them.
Okay.
Because we have a very funny understanding of sub judice. People in this country, including sometimes even the courts, want us to believe that when you say something, you can sway learned men and women. But I see very hot discussions going on in American press when cases are in court. Very hot discussions on television, cable news, newspapers and magazines, all spaces. But here we have a very, I don't know, our understanding of sub judice is really warped up, I think. So that I'm reluctant to discuss things that are within the corridors of justice, because people say you are violating that rule. But I have not followed keenly. There was the issue of the entire Finance Act.
Yes,
it's no longer a bill. There was the issue of certain aspects of that Finance Act. And there was also the issue of inclusions in the act that were not in the bill. I think something like that. Or more, the one I'm very clear about was inclusions in the bill of things that were not part of public participation. I can just cite one. Kenyans were asked to participate in deciding whether or not they can have this housing levy, which was a saving. And they gave their views. But when the bill came out, it was no longer a levy, least of all a saving. Instead, it was now a tax. It was now compulsory contribution. And it's not a saving. That is not what was taken for public participation. So such a clear things should have perhaps moved the court to, if they had to quash the orders suspending the implementation, at least for those particular aspects. So I don't want to go beyond that, because I just think so when we talk about things that are in court, even things that are going to court, like this one you are saying is going to court, you can find somebody even telling you, come here and explain.
So we are here, Prof. Definitely. I hear the Court of Appeal told him that perhaps they had that option of going back to the High Court to demand for the suspension of implementation of specific clauses within that Finance Act, without necessarily having to suspend the entire act. And of course, the government is saying that suspension of that act is sabotaging their plans, their economic plans therein, because they're not able to collect revenue as they expected.
Wrong. That's wrong. That's wrong.
So here we are. Before
you come up with a new act, the existing act is sufficient for government to run. And there is no hurry. Even if you want to build houses, you don't want to build houses. You are not going to build houses tomorrow. So the hurry itself is suspect in terms of government saying they want money. But where the hurry is required, the urgency, and you see, I will soon stop talking about our judicial, because they'll think I'm a bad man. When the courts are seized of a matter like this, there must be some degree of urgency. The court should sit for 5 days and clear this matter once and for all. And when the court is clearing a matter they know is likely, first, that must be done urgently, like the Finance Act. They should do it within 3, 4, 5 days, maximum 5 days. It's done, it's finished. But if they know it's going to move to the Supreme Court, And this discussion I had wanted to have with the president of the Law Society of Kenya. Then he introduced other side issues because people were clapping for him. The dispensation of justice in terms of being expeditious while remaining judicious. If you know this case must be dispensed of quickly, and the High Court has done its best and done it within 5 days, they must do within 5 days, according to me. There's nothing to stop. And you know it will go to the Court of Appeal. The judgment, the way it is written, must be so clearly written. The issues must be as clear as the ones of BBI. They were so well distilled. They were sticking so clear. In fact, they were in 1, 2, 3 up to 21 or 23 from Justice Ngugi of the High Court. You're I think the head of the bench. When they went to the Court of Appeal, the time they took was inordinate. Because the issues are distilled, they are so clear. Why do you want to take 3 months over issues that are very clear? And then, when it left the BBI, I'm not talking about BBI, when it left the Court of Appeal, the matters were now even fewer and even clearer. Why did the Supreme Court have to take all the time they took? So here, this Finance Act, the High Court should take about 5 days. And the judgment must be written in such a way, if somebody because they should expect somebody to go to the appeal, and yet this is an urgent matter, so that government can run and not have excuses. You do 5 days, High Court. You write your judgment in such a simple way, straightforward, with the issue so clear, that the Court of Appeal can handle that matter one afternoon or one morning. Finished. And you write your appeal not more than 2-3 pages. A4.
No, okay, I do get you, but here we are. Of course, yes. We are still waiting to see, or not even waiting, but then, okay, Mtata said he's headed to the Supreme Court to seek the opinion of the Apex Court of the land on these issues here. Of course, he is saying that there are certain things that cannot be reversed. For instance, the taxes to do with VAT, all those taxes which were increased therein, as long as they've already been implemented and they've been collected from people, they cannot be taken back to the people. And that is why he's saying that until such a time that this case is hard and resolved, this entire Finance Act should be suspended. That is, according to him, we're waiting to see what is actually happening therein. But then the country is finding itself in some sort of a weird situation. Yesterday, I saw a number of civil servants lamenting about the deductions on the NSSF, and they are saying that they're being deducted something that has not been there all along. So we are having that. The Finance Act is here. Those increased levies people are being deducted for. In the so-called housing levy and all those things, now that the Finance Act is operational, people are crying foul everywhere. Even the police officers are crying. What do we have now as an option, as a country right now, when we are at a time when everyone is crying, but then there's nothing you can do, because if you go to the streets...
That's why people are in the streets. And that's why people want to discuss.
You go to the streets, you're told you've got no reason.
The people are going to the streets, now the people are going to discuss at a table. You get it? But there's something else that comes out clearly.
You're talking of the people going to discuss at a table, yet we've been told that nothing pertaining to the common man is going to be discussed.
It will be discussed. But there's something else that comes to the surface in this discussion of yours, of ours. And that is that the courts must not allow people who flout the law to appear before them. I don't know, you get what I'm saying?
Just make me understand.
That's why the principle of equity say, he that comes before equity must come with clean hands. If the Attorney General has disobeyed the Supreme Court in terms of CDF, why would the Supreme Court even listen to him? Why would the judiciary listen to him when he comes to appeal anything? They should tell him, how can we make a serious ruling on CDF and you give an advisory and the public funds are being spent? You don't have clean hands. We can't listen to you if you are the AG. At least not you as a person. Perhaps when they change the AG, we can forgive the Attorney General, the new one. And in this particular case, why would the courts entertain government when the government continues to charge people VAT on fuel, 8%, when the courts had stopped it? How does the same court listen to those people? And the courts must assist us to maintain a civil society, civil order. The courts have a critical role to play in making sure this is a society that obeys law, obeys laws. There's law and order in this country. That we follow our constitution. Because sometimes that's the only thing we have to stop us becoming animals. And the courts, I want to urge our courts, and I'll stop talking about the courts in this country. They must help us to remain a civil society.
Okay.
Where there is order. Why would the courts entertain those people? And yet they have flouted the court's rulings. Yeah, they continue to charge VAT when the courts have said no. They suspended the act. And then they go before the courts, and then the courts listen to them. Whoever is sitting in judgment, whoever you are a judge, the bench that is doing that, you are contributing in wearing away, tearing away at a society that believes in law and order, in a civil society where people respect the law and live under the law. You are contributing towards eroding that order. Kidogo tu, you are nipping away. Kidogo tu. You could get yourself to a point where nobody thinks much about our courts. And therefore, we come back to the Hobbesian state of nature, where life is said to be brutish and short.
Okay.
Yes, we are just like animals. State of nature, we are like animals. The judiciary has a critical role to keep the hope burning that wherever there are disputes, whether criminal, civil, or otherwise, they will all be arbitrated in a way that leaves people convinced we have law and order in this country. So how does the court sit to listen to government which has disobeyed them? I challenge the courts. I challenge them because they will be part of those institutions that will destroy this country.
So anyway, you're saying that the court should not actually listen to the government right now. This is something that I've always asked you. You say, okay, that judgment was made by, or rather rendered by the High Court. Then the government decided to appeal it, of course, through the Office of the Attorney General. In such kind of a case, what then do you expect the courts to do? How then should they handle such kind of
The courts should send those people away.
How do you send these people away? Yet the country is
under the principle, I've given you the principle of those who go before the court must go with clean hands and with full disclosure. They should have started by saying that we didn't implement.
We suspended this act.
The court suspends an act. Then you ignore the courts. Then you go to appeal against that. How can the courts listen to you? I told you I don't want to talk about our courts.
Let me leave it there. Now, my bigger question is now, where are we left as Kenyans right now? Because here we are looking at these, a number of Kenyans actually portrayed their distress and dislike to this kind of, this finance act that we're now having here right now. Definitely it's operational and people are already feeling the pinch. People are being told to tighten their belts because they are bound to face hard economic times moving forward, if at all the implementation of this Finance Act continues. And therein,
it has started. I've seen where we used to send them pesa 1,000, they charge you 28, between 1,000, I think up to 2,500. I've seen an extra 1 shilling is now 29. I've just noticed this morning. So it's already working. So
Omtata goes to the Supreme Court. If he loses, then what option do we have? People cannot go back to the streets.
And this again, this is again why I keep going to the judiciary, and I want to stop one of these. I don't want to talk about the judiciary. The judiciary is well aware that we have set these institutions to prosecute certain cases, to impeach certain processes, to impeach certain people. And the people of this country have faith in the institutions, including the judiciary. When the people get to a point where the institutions and the people in those institutions are failing to impeach where they must impeach and to prosecute where they must prosecute, the inevitable often happens, which is the people will prosecute and impeach these people and these processes in the streets. It's a no-brainer. You can't be sitting in a high court without, as a judge, having been trained in law and read books without knowing these simple political issues of across the world. That people have faith in the judiciary and the other institutions. When those institutions fail, the people then take the law in their own hands and they impeach people in the streets. That's how riots and demonstrations happen. And for us as a country, which is still a young country, highly divided along ethnic lines, we don't want street riots. We don't want street demonstrations. They're not good for this country. We have a fragile economy. Every time we have people in the streets, we scare away investors. We lose jobs. Businessmen lose money. The last riots, they were estimating 3 billion per day, which I think to me is an understatement. And that's only Nairobi. So the judiciary must not participate in pushing people to the streets. So when issues come before them, they must be judicious. They must be expeditious. But they must take care of the public interests. Look at the public good. Okay? So if some of these things need to wait, they can wait. But if the courts are convinced that things are okay, then make the thing quickly and people start their new life. As Omtata might be arguing, what is the point of this case taking another 3-4 months and the Kenyans continue paying these new taxes and levies only for the courts to come and say finally that it was not necessary? Already, we have evidence on the table. The fuel levy is being charged, was being charged, even with clear court orders to stop it. So I think the courts must participate in ensuring the public do not lose confidence in the judiciary. It's very, very critical for a society that is orderly.
Even as you talk of people being led to the streets, of course, the government has made its stance. The president, the deputy president, the CS, Interior has said that the streets are no-go zones for Kenyans at this particular moment. I wonder whether we've reached at that particular moment, whereby things will take place in the country.
And that's again another thing. That's another.
There's nothing you can do about it.
That's another area where the courts must also help us. If you hold a person for 5 days, because of demonstrations. First of all, the government is wrong. The Constitution grants people the right to demonstrate, to picket, to go on strike, and all those things, and mass action. Okay? The same Constitution does not envisage a situation where some authority can stop those ones, unless under circumstances that are clear of violations. And the court does not demand that anybody gives them permission. So starting there, it is already wrong.
Okay.
But how do the courts help? The government arrests somebody for 5 days, then produce them before the court. Sometimes without charges. Sometimes with charges, which clearly under Article 49 or what, nobody should be held, because if it is something you can pay a fine or be in prison for 6 months, why would the courts listen to the prosecutor? They should tell the prosecutor, you are not going to use our courts to harass Kenyans. If you arrest somebody, prepare the charges within the stipulated time, bring them, prosecute your case, we make a decision. But for you to bring us people you have held beyond the stipulated time, we will not listen to you. Yeah, no, we will not listen. You are not being, you want to use us. Just like people used to use the police cells. If come out many Corsair, naongea na polisi wanakushika Friday asubuhi saa 6, unakaa paka Monday. So the court should not now replace the police cells. The police cells were being used to teach somebody a lesson. Okay. Shika huyu mtu saa 6, saa 4, saa 5, saa 6 Friday. Ashinde Friday, ashinde Saturday, ashinde Sunday, wachilia ye Monday. So the courts should also not agree and allow themselves to be used the way the police were being used to detain people. So that ukiona deni ya mtu ulipe, unaona masiku imeanza kuna kofia hapo ndani. The courts should also say, no, don't bring us somebody you have tortured. The Constitution is against it. We shall not deal with it. Once there are claims of torture, we'll send this to the institutions that can confirm whether there was torture. And if there was torture, we shall not listen to you. That means it's forced evidence and what have you. Number 2, if you arrest somebody and you don't bring them to court, If you need more time, the place to come is to us. You arrest somebody on Wednesday, bring him on Thursday to us, and ask for time to detain the person. But you have not asked us. You have been with him. Now you are bringing him 4 days later. We will not listen to you. This is how the courts are going to assist us as a country to move forward. Yes.
The courts should be expeditiously judicious. That's what Professor Herman Manyora says here on this episode of the Candid Talk. Ladies and gentlemen, remember to tune into some of our programs that will be coming up next. Daryl Kabiro, as always, will be here. Richard Mwenja, as well as Brian Mundia on the public opinion. Until we have this conversation again, have yourself a lovely day. Thank you for listening. Thank you for your audience. If you've not subscribed, please do subscribe. And thank you. My name is Evans Okinyi.